We've talked about the importance of popular sovereignty as a benchmark for evaluating how a democracy is doing. We've talked about political equality, again, as a benchmark to evaluate how a democracy is doing and how well it's living up to the ideals. And the last thing I want to talk about is political liberty. Now, I'm speaking about them as if they're three specific, unique things, but they're all intertwined with one another. But it's important to try and disaggregate them as much as possible and try and understand them, each of them. But as I've said, we'll come back to these topics over the course of this class and return to this idea of assessing where we are in the United States. And it's not my expectation that everybody's going to agree with one another or with me for that matter, but just to have an informed opinion is all that I'm looking for. So generally speaking, when I'm talking about political liberty, I'm talking about non-interference with freedoms that are essential to the formation and expression of preferences. And that's another one of those complicated definitions that I need to elaborate on. When I talk about non-interference, I'm referring specifically to the government not interfering with these particular freedoms. Oftentimes people think that the First Amendment, for example, which protects freedom of speech, that this requires businesses to allow speech to happen within their establishments. That's not the case. The First Amendment, and we'll talk about this more in the future, is a limitation on the government restricting freedom of speech, specifically the government. So when I say non-interference with freedoms essential to the formation and expression of preferences, what I'm talking about is the ability to tell the government, whether we're talking about the national government, state government, local government, the ability for people to express their views, to form their views, and then to express their preferences, what it is they want done, what they think the government should be doing. That if the government is interfering with the ability of the citizens to form opinions by restricting access to information, by limiting what people can say, if the government is preventing people from speaking and communicating their preferences, this shows a lack of political liberty. On the other hand, if the government generally doesn't interfere with these, the ability to express these preferences, then that means there's a lot of political liberty. And in fact, I would argue, and again, people are welcome to disagree, that when it comes to this understanding of political liberty, there's a ton of, we're doing a really good job in terms of political liberty in this country. People have the right to say the craziest stuff without being interfered with by the government. Things that are said on social media are just sometimes nuts. People say things that are just like outrageous, offensive from my perspective, and yet we're allowed to say them. So for example, a few years back, so I think it was in 2018, 2019, there was a group called the Westboro Baptist Church. Now let me be clear, I do not think the Westboro Baptist Church reflects the views of people who identify as Baptists. What this group did and what they were doing is they would protest in front of cemeteries. And they would do these protests to make a statement. Now, I'm going to use a derogatory term for homosexuals, and so I apologize ahead of time for this. I don't mean to offend anybody. But they have a website that's called wehatefags.com. And when they protest at these cemeteries, it's always when a soldier has died and is being buried. So that as a family is coming to bury their father or mother or daughter or son or uncle or aunt, these people would be standing outside with signs with that awful phrase, And their argument was that the reason that this soldier died is because America was caving into what they called the homosexual agenda. Now, I don't know how you feel about that, but I find it repugnant. But at the same time, I think that speech is protected. I think they have the right to say what they want to say, even if it's offensive, maybe especially if it's offensive. It doesn't mean they have a right to say it anywhere. And so different localities passed laws that required them to be a certain number of feet away the entrance of the cemetery. Yes, you have the right to say what you want to say, but you don't have a right to say it anywhere you want to say it. Well, freedom of speech is one of the most important forms of political liberty. There's also freedom to join associations. There's also freedom of the press, which is essential, and we'll be talking about that later on in the class. But freedom of speech is like one of those complicated things where all the rights that we have are conditional. They're conditional, meaning they're not limitless. You can't say anything all the time, anywhere. And so in this next video, they talk about where the line is drawn in the United States. At what point is speech no longer protected? And I think one of the things that you'll find is that you can say a lot and it's protected. You have to cross a very, very clear line in order for your speech to be not protected by the First Amendment. So listen to what she has to say, and then we'll talk about it on the other end.
We all know the First Amendment protects almost all speech. But when does speech cross the line into something that's unprotected, like incitement to violence? My name is Lee Rowland. I'm a free speech attorney with the National ACLU, and we're going to talk about the law of incitement. The First Amendment to the U.S. Constitution, by default, protects almost every bit of speech that we can engage in. But there are a few areas where speech crosses the line into something that's considered violent or criminal. One of those areas is incitement. Incitement to violence is a term that refers to speech that creates an immediate risk of harm to another person. It's kind of like a threat, except it's done through another person, which is to say, rather than threaten you directly with harm, I suggest to another person, why don't you hurt her? Under the First Amendment, it's an extremely high bar before speech can be criminalized as incitement. But unless and until there is an immediate and serious risk to a specific identifiable person, that speech can't be made criminal consistent with our First Amendment. A tour of the Supreme Court's history with incitement law provides a beautiful illustration of what we mean when we say that the First Amendment is indivisible. It applies equally to, say, a white supremacist and a racial justice advocate. I want to talk about two cases that have hit the Supreme Court just to illustrate the breadth of speech that is covered by the First Amendment. The seminal case in which the Supreme Court set this incredibly high bar for what speech becomes and can constitute incitement is called Brandenburg. And even until today, lawyers often refer to the incitement doctrine as the Brandenburg test. Brandenburg was a man who was a literal leader of the KKK, and at a Klan rally, he expressed the kind of hateful and disgusting racism you would expect from a Klan leader. And as part of his speech, he basically fantasized and encouraged generalized violence against Black Americans. He was charged with incitement, and his case made it all the way up to the Supreme Court. And the Supreme Court determined that Mr. Brandenburg had not committed incitement because there was no particular individual he was suggesting be harmed. He didn't create a plan of action for hurting anyone. He spoke in general and vague terms about an all-white future. He also said unbelievably hateful and disgusting things about Black people, as you might expect from a leader of the KKK. But at no point, the Supreme Court ruled, Did his speech, did his words become an immediate roadmap for violence against other people? Brandenburg might be tough to swallow in a vacuum, right? A nearly all-white Supreme Court saying a KKK leader, of course his speech is protected under the First Amendment. But if you just wait a handful of years, we really get the end of the story of incitement in the next major case, NAACP v. Claiborne Hardware. Even from the title, you probably suspect there's going to be an interesting counterpoint to the Brandenburg case. In NAACP versus Claiborne, a bunch of white-owned businesses had filed lawsuits against a lion of the civil rights movement named Charles Evers, who, at a rally organized by the NAACP, engaged in really powerful rhetoric encouraging people to boycott racist, whites-only businesses. And he said during his speech, "If anybody breaks this boycott, I'll break your neck." Now, potential for future violence? Absolutely. Vulgar? Yes. The question is it protected speech? It went, again, up to the Supreme Court. The Supreme Court looks to Brandenburg and says, we've set this incitement bar really high, so high that it protects a KKK leader at a rally suggesting that black people should be killed. Now we've got a civil rights leader at a rally suggesting that at some point some people's necks might be wrung. Well, guess what? Charles Evers' words were protected specifically because the Supreme Court ruled that he fell under the Brandenburg test. The Supreme Court recognizes, rightfully, that political speech often involves really passionate, sometimes violent rhetoric. And unless and until it creates a specific and immediate roadmap for violence against others, it cannot be criminalized consistent with our First Amendment.
Now, there are some people who think that the amount of freedom of speech, freedom of the press that we have is too much, that it allows disinformation to be spread. It allows really terrible things to be said about people, about public officials, about which they have no ability to respond. The thing that I would caution everyone about and hope that you would consider is that it may be that right now your views are not something that people consider terrible or offensive or obnoxious. But when you are protecting the rights of people like the Westboro Baptist Church to say the things that they want to say, you're also protecting your freedom of speech. You're protecting your right to speak. And so I'm going to make the first prediction in this set of videos. On January 6th, 2020, there was an attack on the Capitol building. It was an effort to stop the counting of the electoral votes and overturn the outcome of the 2020 election. In the process of investigating what happened, the special committee in the House has been discussing, at least currently, as I'm recording this, the possibility of pursuing criminal action against President Trump on the grounds that he incited that riot, that attack on the Capitol. And I think if you consider how the lawyer explained the rules are, my guess is, here's my first prediction, I could be wrong, no charges will be filed against the president. I would be surprised if anybody who was on the stage on January 6th is charged with incitement because of the very specific nature that the threat has to have. There were generalized comments about what should be done, but you can judge for yourself. Did they meet the standards that the lawyer was talking about? And I would submit to you that they didn't. And as a result, there won't be any prosecutions. Now, I'm putting this down, I'm recording this, and maybe I'm totally wrong, and we'll know. So if you're taking this class in 2023 or 24, 25, you might be like, Phil, you were dead wrong. Okay. It won't be the first time, it won't be the last, but that would be my guess. In the next videos, we're going to be talking about different ways that political scientists sort of characterize the kind of democracy we have in the United States. Whether what we have is majoritarian democracy, what we have is a form of democratic elitism, or if what we have is a pluralist democracy. That's what's coming up.